Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video is intended for law students of tort law. Dear students, we are going to discuss the general defense, that is mistake. Please remember, there are two types of mistakes: mistake of fact and mistake of law. Mistake of fact can be excused and mistake of law cannot be excused. There are two legal concepts, two legal maxims in this regard. That is, ignorantia legis neminem excusat. Ignorantia legis neminem excusat. That means ignorance of a fact or legislation. Ignorance of fact is excusable, whereas ignorantia juris means jurisprudence, law. Ignorantia of law is non-excudat. That means ignorance of fact can be accused to some extent, but ignorance of law can't be accused. This is a legal maxim. So while dealing with when I told you the mens rea and actus reus, I told you the case of R versus Tolson and R versus Prince. R versus Tolson, in this case, the woman married another person after 6 years, believing that their previous husband died. But ultimately he came back within 7 years and he filed a case. But the Privy Council took that, in fact, she was of the impression that he died. So, factual mistake, definitely mistake of fact, therefore it is allowed. So please remember, mistake of law will not be allowed. For that, yesterday in the class I told you how many laws, how many statutes, how many acts, how many GOs are there, we do not know. So it is highly impossible for a person to know the law. But please remember, if you say that if you feel ignorance of the law, it can't be excused. You are supposed to know the law. ప్రజల అందరికీ చట్టాన్ని గురించి తెలిసి ఉండాలి. నాకు ఈ చట్టం ఉందని తెలియదు అంటే ఒప్పుకోరు. బై మిస్టేక్ చేశాను, వీడు వాడనుకున్నాను అంటే కొంతవరకు ఒప్పుకోవడం జరుగుతుంది. సో దిస్ ఈస్ ది బేసిక్ టాట్. ఇట్ అప్లైస్ టు అదర్ ఆస్పెక్ట్స్ ఆల్సో. నౌ విల్ గో టు ది కేస్ లాస్. సో యాజ్ రిగార్డ్స్ మిస్టేక్ ఆఫ్ లా సందర్భం వచ్చింది కాబట్టి అకాడమిక్ ఇంట్రెస్ట్ మీద మీకు చెప్తున్నాను. దిస్ ఈజ్ నాట్ అప్లికబుల్. మిస్టేక్ ఆఫ్ లా అండ్ మిస్టేక్ ఆఫ్ లా ఫ్యాక్ట్ ఆర్ అప్లికబుల్ in section 76 to 79 of the Indian Penal Code. That is for crime, not for tort, but sandarbham vachindi kabatti. Please remember. So normally mistake of fact can be a good defense to some extent only. Mistake of law cannot be a good defense. Of course, here also, even though you are able to prove that by mistake it happened, your burden or your burden of paying compensation may be lessened to some extent. That is only the advantage with this defense. It is not a pure defense, I can tell you. Right. So normally A and B are playing games in a laptop. After the game is over, A takes away the laptop belonging to be his. Now he cannot take the defense of mistake of fact as per law. No. It is not your property. If it is not your property, you take it, it amounts to theft, it is a crime. So you have to remember this. Now we'll go to case laws. The state of Maharashtra versus Major Hans George, 1965. So actually, the court appointed their clerk, or they call it as Sirdar Samkada, their clerk, to go and arrest one Hans George, because he failed to execute or he failed to pay his part in repaying the money in execution proceedings. That means ఒక ఆయన కేసు వేశారు, ఆ కేసులో డబ్బులు రావాలి, ఈ హ్యాండ్స్ జార్జ్ అతను ఇవ్వలేదు కాబట్టి అతని మీద సివిల్ కోర్టు కూడా వారెంట్ ఇవ్వచ్చును, అతను అరెస్ట్ చేసి తీసుకురమ్మన్నారు. But the court officer went and brought Major Hans George because names are similar and almost identity is also similar. తీసుకొచ్చిన తర్వాత it was proved that Hans George is another person. So that means by mistake the court officer arrested Major Hans George in place of other Hans George. So definitely he will get aggrieved, is it not? నేను కేసులో లేకుండా నన్ను తీసుకొస్తే ఊరుకుంటావా? డెఫినెట్లీ హీ ఫైల్డ్ ఎ కేస్. But here, the court. So, of course, the lower court did not agree. Come on, how can you bring another person? You pay the fine. But when the matter was appealed, అందుకని మీకు the state of Maharashtra versus Major Hans George. State, and that means court went in appeal against the orders of lower court. Ultimately, the Supreme Court, in its wisdom, held that the court officer can take the mistake of fact in good faith. By mistake, they meant overstated. Of course, what happened is after coming to the court, the judge released him. This is a relief. So anyway, it cannot be, it is not taught. That means here the responsibility is lessened. Right? It's another case. Keshav Singh versus Saligram Shah, 1977. So there was information to the police officer Keshav Singh that smuggling is going on in the house of Saligram Shah. The defendant was carrying on smuggling business in his house. Immediately, actually, they went to the house of so-called Saligram Shah, but nothing was found. But still, they suspected a small cart containing some rice. Maybe smuggling, or they do not know. Anyway, they brought the cart and the person to the police station. Right? So then what happened is it was proved that it is the wrong information, and later, so they have to let him off. Then he filed a case against the police officer. So Keshav Singh, yes, stating that these people, Keshav Singh, filed, actually this man filed, Shaligram Shah first filed, ultimately the matter went in appeal. So case was filed against Keshav Shah. The lower court held that police are responsible. How can you take an innocent person? You should have checked on the spot. You did not do so. You are liable to pay compensation. Of course, the matter went in appeal. So Court of Appeals, the said suspicion was proved, even though it was proved to be wrong, it was held that it was held to be mistake of fact, and it is justified by law. So no compensation need be paid. So these two are the positive examples. Now we go to the negative example. So Consolidated Curtis and Co versus Consolidated Co versus Curtis, 1894 case. 1 minute, let me look to that. 1894, exactly. So Consolidated Co, this is also appeal matter. What happened is the plaintiff asked the so-called Consolidated Co persons, plaintiff is Curtis, he asked the Consolidated Co persons to auction some of his properties. But what happened is, auction means normally it happened in other countries. When they get a transfer, they will keep all the properties in the storage rooms arranged for that purpose. Specifically for that purpose, there will be so many storerooms. So they will take the keys of the room, they will keep their property. So instead of keeping them waste, he asked the Consolidated Co people to sell them away, to auction them away. But what Curtis has done is, he has disposed or he has sold away the properties of another person and paid the money to this man. The other person, so definitely Curtis got annoyed. How can you sell my properties? The properties who asked, actually, అయితే ఎవరికైతే అమ్మాలో ఎవరి ప్రాపర్టీస్ చెప్పాడు అమ్మకుండా కన్సల్టెంట్ కూడా వేరే వాడు అమ్మేశాడు. సో డెఫినెట్లీ whether it is a mistake or not, there is a point. The court said no mistake. It is your duty as in charge of the warehouse. You have to be more careful. So therefore, it is amounts to conversion. That means you have converted into your own property. So therefore, you are liable to pay compensation. Negative example, కొంచెం జాగ్రత్త గుర్తుపెట్టుకోండి. ఇక్కడ నేను ప్రాపర్టీస్ అమ్మమన్నాను, కానీ నాయి కాకుండా కర్టిస్ ప్రాపర్టీస్ అమ్మాడు. అమ్మినప్పుడు నా ప్రాపర్టీస్ ఏమైనా ఎత్తుక్కుంటే లేవు, ఎందుకంటే అమ్మేశాడు. సో ఎస్, ఇట్ ఈస్ నాట్ అలౌడ్, ఇట్ ఈస్ నాట్ ఎ మిస్టేక్ ఆఫ్ అ ఫ్యాక్ట్ అని చెప్పి కోర్టు కాంపెన్సేషన్ వేయడం జరిగింది. సో దీస్ ఆర్ ది కేస్ లాస్ రిలేటింగ్ టు సో కాల్డ్ మిస్టేక్ ఆఫ్ ఫ్యాక్ట్ అండ్ మిస్టేక్ ఆఫ్ లా. రైట్, థ్యాంక్ యూ వెరీ మచ్.